This is the Law 401 podcast, legal issues decoded for you, brought to you by Roger Williams University School of Law.
Welcome back to the Law 401 podcast. I am one of the co-hosts, Michael Donnelly Boylan. I am also one of the associate deans at Roger Williams University School of Law, and this is my co-host.
Hi, I'm Nicole. I am a lawyer, a librarian, a law professor, and I'm really excited to dig into today's topic. So we're talking today about the ways in which people become judges in Rhode Island.
So you may have noticed that on September 29th, the Providence Journal ran a front page story by political reporter Katherine Gregg with the headline, "How Can You Become a Judge in Rhode Island? Start with Political Connections." It laid out how judgeships, lifetime jobs that can pay nearly $270,000 a year, are often tied to family ties and political connections.
Yikes. That is a headline. The article by Kathy Gregg pointed out that right now, Rhode Island has at least 7 judgeships and 2 magistrate positions open, with more expected because of some anticipated retirements. And many of the names under consideration have connections to lawmakers, party leaders, and even other judges already on the bench. And this is not a unique phenomenon.
So today we're digging into that Projo story. We'll be talking about how the system works, why it was designed the way it was, and whether the reforms of the 1990s really solved the problems of patronage and politics in Rhode Island's courts.
Our guests today are one of our coworkers, former dean and professor Michael Yelnosky, although I don't even think he's way more exciting than I just made him sound, and the executive director of Common Cause Rhode Island Common Cause, John Marion. So excited about today's conversation because I don't think there's anyone in our state that knows more about this topic than them.
So, Michael, let's start with the basics. For someone who just saw the headline, why should an ordinary Rhode Islander care about how judges are picked here?
So I think there are a couple of reasons. We should care about how our judges are picked because we care about who our judges are. And we care about who they are because they have a significant impact on our lives. Whether you're appearing in the traffic tribunal, or you're the victim of a crime, or you're a defendant in a criminal matter. I know you've spent time talking about the Washington Bridge litigation. All of those matters are decided by judges, and they have a lot of impact. Confidence in those judges is essential to a healthy democracy and a healthy civic life. If people think these are just patronage positions, then I think the state suffers. And finally, these are powerful positions, as you mentioned, and I think it's important, again, in a democracy for powerful positions, high-paying positions, high-status positions, to be available to all of the people who have the qualifications to do those jobs and not just to a select few.
I think this really hits me because I think as a young girl, you're told you can be anything you want to be. You know, you could be president, you could be a judge. And you see this sort of model of RBG, and you see people on Halloween have their little kids dressed up as RBG. But then when you read a story like this story by Kathy Gregg, which we'll have in the notes to the podcast, and I highly recommend you read, it makes it feel like, well, maybe I really can't be anything that I want to be. Maybe working hard and getting education really isn't enough to be a judge. And I think that it kind of cuts a little bit away at the American dream. And I don't think I'm saying anything controversial, but there are so many conversations happening right now about the eroded trust in our government and whatever branch of the government you feel that about. I feel like the conversations are happening on TikTok in real life, and it's a big deal.
Can I just add something before
Please.
and John will talk about this as well, I think. I thought Kathy's piece was terrific and shone a light on things that need to be discussed. But I do think it's important to recognize that there are lots of judges in our state system who did not have family connections, who did not come from the General Assembly, who probably otherwise would not have been judges under a prior system. So this is a mixed bag, I think.
Yeah, and the article was trying to make the point that folks who have political connections continue to be able to use those in the system, but it doesn't talk about this entire wave of judges, mostly in the last 10 years or so, that we've seen who, like Michael said, otherwise probably wouldn't have been on the bench in another system. And that's a real success story because it didn't happen right away. The system's about, 30 years old, but it took a couple of decades for it to really sort of kick in. And it took actually an aggressive governor in Gina Raimondo to take advantage of her power in the system to really start particularly diversifying the bench with respect to race, but also career experience, age, a number of different measures of diversity.
I think one of the things I'm already picking up is this is probably not going to be something that we cover in its entirety in this episode. Mm-hmm. That I think maybe we need to consider having this be like affordable housing is, something that we touch back in on.
Yeah, I mean, this is literally, I think, one of the reasons why the law school was formed in the first place. So I think this is a topic we should come back to on a regular basis. So,
John, Kathy Gregg's piece framed judicial selection as a question of independence and legitimacy. From a good government perspective, and maybe you want to share a little bit about who Common Cause is, and I should do my own due diligence and say I am a member of the Rhode Island board of your organization. What does independent court really mean for the public?
Yeah, so for those who aren't familiar, we're a national organization. I run the Rhode Island chapter of it, and we work on a variety of sort of pro-democracy issues. Back in the 90s, when Michael was on our board, we worked a lot on creating a new system for picking judges in Rhode Island after a series of scandals we'll get into. And
I'm sorry, did you say scandals?
Scandals.
Ooh, now we have something to look forward to.
And our organization usually tries to encourage processes that are transparent and rely on merit and, de-emphasize sort of politics and political connections. So there was this was sort of a natural issue for us to work on in the 1990s. The guide star back then, as I understand it, and I wasn't involved when it originally happened, was to try to create a system where the judicial branch was not reliant on the legislative branch the way it used to be. You should have 3 separate and equal branches of government. But in our system in the United States, one of those branches is usually picked by one of the other branches or 2 of the other branches in the case of the judiciary. So creating that independence and separation is really a difficult thing to do systematically. It's important. We see in the headline every single day when a federal judge, rejects something the Trump administration is doing. Oftentimes the article says a former Reagan, appointee, a former George W. Bush appointee, a former Obama appointee. Many of them are pushing back against what the executive is doing. They can only do that because they're independent of the executive branch, because they have life tenure and they can't be forced into retirement. And so that's what we did in Rhode Island. We are the only state in the country that reformed our system to give every state judge life tenure, no retirement. The other 49 states do it some way different. And we went all the way in for independence.
Can I ask a follow-up question just about your organization? Are you a nonpartisan organization? And do you find yourself sort of in hot water when you're trying to sort of push good government or be pro-democracy?
Yeah. So, yes, we're nonpartisan. Many of our positions sort of skew to the left side of the spectrum, but mostly because our issues have sort of polarized. I would say 30 years ago, most of our issues were not polarized. Ethics was not a partisan issue, but I think it is today, particularly under the Trump administration. But we continue to sort of, our tagline is holding power accountable. In Rhode Island, the Democrats had power. We try to hold them accountable. If the Republicans had power in Rhode Island, we try to hold them accountable. This issue is interesting because it's not necessarily a partisan issue. It has more to do just with sort of raw power and whoever holds raw power. We're going to talk about, Democratic state legislators, but we've had a lot of Republican governors who've been a part of the creation and sort of fulfillment of this system over the years, for better and for worse. And who've taken advantage of their power in the system. It's interesting. One of the advantages I have, I'm not an attorney, and if you're an attorney, and many politicians are, you need to be careful what you say about this subject, because you're going to appear before these people. I don't appear before these people. I drove the speed limit on my way here to tape this podcast because I don't appear before the judges. I think we have a little more freedom as an organization to kind of share our opinions about the topic.
CS non-lawyers actually have some power in all of this.
Constitutionally speaking, I think you might be a speed limit driver.
Yes.
John, that was a great segue to our next sort of set of questions, which is about the history. It's hard for us to really dig into what's going on now if we don't really know what happened before. So can you talk about merit selection, and before 1994, how did the state of Rhode Island pick judges?
Yeah, so before there was sort of a bifurcated system. All judges below the Supreme Court were picked one way, essentially kind of the federal model where the governor would just pick them and there'd be advice and consent from the Senate. And then the state Supreme Court was picked in this very unique way. They were picked by something called the Grand Committee. And the Grand Committee was the House and the Senate sitting together in a locked room, and poof, out came the judge. It was kind of like electing a pope. Oftentimes, they would open the doors and out would come the Speaker of the House of Representatives, who is now our new Chief Justice, or the Speaker's best friend, who is now our Chief Justice, or a member of the Supreme Court. That was really
surreal.
It sounds surreal, but it happened in 1976. Joe Bevilacqua went from being the head of one branch of government to the next day being the head of the other branch of government, as from Speaker of the House to Chief Justice of the Supreme Court. And his members of the House voted for him to become Chief Justice. It was a vestige of the fact that Rhode Island has this very weird constitutional history where we had a supreme legislative branch until the 1840s and even beyond the 1840s. And so it concentrated a lot of power in the legislature, and one of those powers was picking our justices of the Supreme Court. Bevilacqua got impeached. He resigned before the impeachment went through. Here's the scandal part for associating with the mob in Rhode Island. He was caught by the state police coming out of a mob hotel where he was allegedly having various trysts. And so
that was a very polite way of putting that.
Yeah. So
I watch a lot of reality TV, as our longtime listeners know, and I've never once heard it called having some trysts.
Yes,
that was very conservative.
It was very careful. And so, Bevilacqua resigned in 86, I believe, and they tried to change the system in 86, but the voters rejected it on the ballot in 86. And then his successor was a guy named Thomas Fay, best friend of the Speaker of the House, who then, as soon as he became Chief Justice, hired the Speaker of the House to be his court administrator. They created this sort of patronage empire that the Providence Journal exposed and actually won a Pulitzer Prize for exposing. Fay was impeached, resigned before that went through, and was prosecuted, went to jail. And so at that point in 93, 94, we were able to get a question before the voters to change to this merit selection system. So we went from sort of a bifurcated system to a system where all judges are picked essentially the same way. They're picked by an open application process to something called the Judicial Nominating Commission, who then conducts interviews, public interviews of some of the folks who applied, takes testimony for and against those people that they're interviewing, and then has to send a list of 3 to 5 names to the governor. And the governor has to pick off off that list of 3 to 5 names. There's a twist for the Supreme Court where if somebody gets nominated by the governor for the Supreme Court off that list, the House and the Senate have to give their approval. Again, not something you see in any other state, but a vestige of that grand committee. So we still have vestiges of that old system. For all other judges from traffic tribunal up to the Superior Court, they get advice and consent to the Senate, which is just like we see in the federal system. The idea there is there's a public vetting process, right? Unlike the federal system where, the president just picks somebody and sends their name to the Senate. Here, that person sort of has to face the public. Here, a group of 9 people on this Judicial Nominating Commission get to ask them questions. So it's supposed to be more transparent, allow for public input, and allow for anybody to apply, whether they have political connections or not.
But who picks the Judicial Nominating Commission?
Go ahead, John.
Yeah. I mean, that was probably, we'll get to some of the flaws in the system. In many states, it is a combination of the governor and the state bar. Here, the state bar doesn't have a role. Here it is the governor picks 4 and legislative leaders of both parties pick the remaining 5. And so the legislature still has a role on the front end in a way that they don't in most states.
So how do other states choose their judges?
So a number of states elect judges, which is important to realize when you're thinking about options for selecting judges. Some have gubernatorial appointment with confirmation by one house of the legislature, typically the Senate. And then there are a group that do something like what we call merit selection. And there are variants in all of those processes, but I think those are the 3 primary ways that that judges are selected in states across the country.
And then just in a really basic for anybody to understand, so these people get appointed to the Judicial Nominating Commission, and then a call goes out for applications. People apply. Then what happens?
So as John mentioned, the first thing that happens is the applications go in. The commission votes on who to interview. That's the only process that isn't completely transparent. What we know is who emerges from that process. From that moment forward, everything happens in public. They then interview the candidates. They solicit public testimony about the candidates. Anybody can come forward and in a public session talk either in favor or against candidates. They vote in public on the candidates. Those votes are recorded, so we know which commissioners voted for which candidates, and we also know which commissioners were appointed by, well, they're all appointed by the governor, but we know if somebody came from the speaker's list or the Senate minorities leaders list. And then the list of 3 to 5 goes to the governor. That list is public, sort of another opportunity for people to weigh in. Then the governor selects from that list, and then that name goes to the Senate in the case of the lower court judges, and to the House and Senate in the case of Supreme Court judges.
So let's say we want to be part of the process. We're just regular people who live at home and are listening to this and find that there's some candidate we don't like, or we don't think has enough experience, or, they don't watch reality TV, which is a problem. You're saying once there's a list of who has been accepted for interviews, we can send a letter to the commission, we can go to the hearing, we can testify at the hearing, and then we could send a letter to the governor when the list is at 3 to 5 and say, I think this is a bad person or whatever?
Yes, and you could send a letter to your legislator if he or she is in the the body that will confirm or vote on confirmation. And even on the less transparent piece of the process, if you know someone is applying, you could write a letter on their behalf in the hopes that they will get through that first cut and end up being interviewed by the...
I think that's really helpful because what I see is that there are people who want to be involved in the process and have no idea practically how to be involved. And it seems like it's happening over there being like not where I am, some other place, some other group of people. And this provides like I wouldn't say like an easy to follow roadmap because you still have to write the letter and you still have to contact your legislator and you still have to show up in public for or against somebody. But at least it makes the steps like easy to understand and accessible if I feel strongly about a particular candidate.
And it happens at a public meeting, right? So you have notice and they actually schedule their meetings way out. And so if you contact the Judicial Nominating Commission, they have a website, they'll put you on a list and they'll send you an email way out before their meeting happens. And it's interesting because in 30 years, right now, there's this sort of first effort to mass mobilize against someone. So there's a former Senate Majority Leader, Michael McCaffrey, who's applied for a district court position. And there are several groups who are mobilizing their members against him. Normally, once in a while, somebody kind of weighs in against a candidate. We've weighed in once, but you don't see mass mobilization happening. It's happening for the first time. It would not be possible but for the fact that there are public parts of this process.
So do you think this is a sign that the current process is actually working? Or?
Yeah, I mean, we'll discuss, it's not working perfectly and not all of the parts are working correctly as they're supposed to. But yeah, the fact that people had a venue to make their voices heard and the people who are making the decisions had to listen to them. You can write letters and people don't need to read them. But when they're sitting in a public meeting and you go up to physically testify, they can't help but have to listen to what you're saying. And so there's, I think, real value in that. Whether or not, the advocates are successful or not, which I don't think they will be, at derailing McCaffrey's nomination, they made their point.
But it's interesting. I think it's still a baby system, really, when you think about it. And I think we've seen it change and mature over the years, as John described. The early public hearings were love fests, basically. Everybody would collect people to come forward and say, this person's great. And that's helpful. But I think, as Nicole suggested, there are people now who look at the process and say, there is an opportunity for us to get involved. And we're seeing more of that. That strikes me as a helpful development.
For us, that's why we're doing this, right? Mm-hmm. Like, we're doing this so people can access law. Like, and, we're not like practicing lawyers. We're not meeting clients to go through their taxes.
Or even a lawyer.
Right. You're also not from Rhode Island, which I like to make an effort to point out in every single episode. But we're trying to make the process clearer because I don't think people can meaningfully engage in a process and meet the moment if they don't know what the process is.
Well, I told Kathy Gregg, and I tell people this all the time, that there is, if we're upset, if the voters of Rhode Island are upset that somebody with family connections gets a judgeship, there is a way to hold those people accountable. It's noisy, and democracy doesn't always work perfectly, and most people don't vote based on who their senator or representative voted to confirm. But that possibility is there. You will know who voted for a candidate you don't think is appropriate, and you could try to hold that elected official accountable.
So the article says there are 7 open judgeships and 2 magistrate slots open. How does that affect the average Rhode Islander? And also, can you just please explain what a magistrate is in theory to begin with?
So let me do the first question first,
Yep.
and then I'll pass to John for magistrates. But the the vacancies exist because of retirements mostly, and that we can't really control when those come up. I know we're going to talk a little bit about mandatory retirement, which would be more predictable. But so the vacancies are there. One of the reasons you end up with stacked vacancies is either you have a lot of judges who retire at the same time, or, and this has been very common throughout the history with this system, the governor decides not to fill a single vacancy and waits until several stack up. Sometimes the justification is that the General Assembly is not in session. Sometimes there's no justification given. I don't like that process. First, it's completely inconsistent with the statutory language, and generally, all other things being equal, I'm in favor of lawfulness. But maybe more importantly,
I'm sorry, we just broke some news here. Former dean of the law school,
all
and
other
current
things
professor
being equal
for lawfulness. Back to you, Michael.
And what happens, or what it permits to happen, is something that the system was intended to prevent, which was political horse trading. So if I've got 4 judgeships I can fill, I can have a conversation with legislative leaders about, I give you this one, you give me this one. The hope was these were going to come up in real time, and the decision would have to be made in real time. And so that's something that I think is problematic, and that the system actually anticipated. What we didn't anticipate was flat out just going to ignore the times.
Right. So this isn't just an issue of the baby boom retiring all at the same time.
No, there's some of that going on. And the other thing I want to assure people is that, at least at the moment, because these vacancies are spread across a number of courts in Rhode Island, there's no court that is suffering from a serious staffing problem that's impacting litigants, as far as I know.
That's helpful. And can you tell us what magistrate is? Because that just seems weird to me when I hear it.
Yeah. So magistrates are defined actually in the law as judges with limited jurisdictions, right? So typically they're folks who can do certain things that a judge can do, but not others. So, for instance, usually can't hold trials, but they could hold an arraignment. And so there was, I think, a single magistrate back in the 90s in the Superior Court when this new system went through, and then and they were picked by the court itself, and their powers were defined by the law. And then after 1994, the General Assembly discovered, this is a way to get around this new system. So they created about 24 magistrate positions in various courts, from the traffic tribunal up to the Superior Court. And those are picked in a different way. They're usually picked by the presiding judge of that court, but not always. And they created a new avenue for patronage. The article really doesn't talk about it that much, but there was just some extraordinary picks in that first wave, including the sitting Speaker of the House, John Harwood's wife, who became a magistrate. And they've stopped creating a lot of new ones recently, but for a while that was sort of the growth industry in the judiciary. The funny thing was, in defense, they said, well, they're not really judges, even though the Code of Conduct for judges actually defines them as a judge, and they can be disciplined in the same way. Recently, the family court, actually, magistrate got caught. He was holding a trial, and the losing party raised the fact that legally that magistrate wasn't allowed to hold a trial for a contested divorce case. And the General Assembly came in and changed the law to allow the family court magistrate to hold a trial in a contested divorce case. So they kind of they made the law retroactive, which you almost never do when you pass a statute. Say, and this statute is retroactive. They got caught with their pants down, quite honestly. doing something they weren't supposed to do in the family court, and they got the legislature to cover for them. But we've long said, listen, if these are judges, put them under this system, for better or for worse. This is transparent. The magistrate selection process is opaque. The presiding judge mostly just picks one of the applicants without a public input process. Interestingly, I think because of the criticism, some of the courts have tried to make the magistrate process a little more transparent over the years. And I think that's a good example of where sort of some of this criticism has helped force some of this into the sunshine.
Can I just make one more point about magistrates that I think is important? So it's not just an end run to get a quasi-judicial officer on the bench, but one of the dynamics that we've seen, which sort of makes sense when you think about it, is if then a real judge vacancy comes up on that court, guess who's really qualified for that judgeship? The magistrate. And a judge on the court, often the presiding judge, can testify before the Judicial Nominating Commission. You don't have to guess about whether this is going to be a good judge, because I've seen this person do the job and he or she will hit the ground running. And that may be true, but it's not the way the system was designed.
Yeah, it's almost like a company, and the CEO brings his son in to be an intern, and next thing you know, the son's hired because he has the experience.
Yeah, and we've seen it particularly with former legislators, right? So a big goal of the reform in the 90s was to sort of just sever the direct tie between the legislature and the bench. And for a while there, you didn't see many former legislators going on the bench. But we're starting to see that creep up a little bit. But oftentimes they start as magistrates and then they become judges, as Michael described. And it's interesting, there's sort of this political, there's a lot of defensiveness on the part of some of the former legislators who've gotten on the bench. But if you go back and read the contemporary debate that was happening in the mid-90s around this, like, this was the point. And I just want to mention one other thing that is a little bit of a non sequitur, but it wasn't actually the JNC that accomplished severing that tie, and it was the State Ethics Commission, whole separate body, but they passed something in the 1990s called a revolving door that basically said if you're a legislator, you can't take a position in state government, including on the judiciary, for at least a year after you've left office. And that revolving door had a lot to do with sort of stopping legislators going directly to the bench. It was very successful.
That's like a whole nother episode.
Yep.
But I do want to push back a little bit. Our legislators work so many hours. It's a part-time job, but many of them have full-time jobs. And they write the laws. They figure out the budget. They work with so many Rhode Islanders. Why isn't the person who writes the law and has the committee hearings and votes on the law a perfect person to then become a magistrate and make sure that what the judicial branch is doing is in line with the very laws that they pass?
I mean, they might be, right? But so might be a public defender or a prosecutor in the AG's office or an attorney in private practice. The problem isn't that they're not qualified. The problem is that they can put their thumb on the scale to get appointed. And, if you have too many people from the legislature on the bench, the legislature is probably going to be less reflective of the people of Rhode Island, because the legislature historically really hasn't been very reflective of the state's population. And it might be, the bench as a whole might be sort of biased toward the legislature's point of view versus maybe the executive's point of view, or maybe, the defendant's point of view. You want a diverse bench, viewpoint diverse bench. You don't want them all just sort of adopting the legislators' view of the world.
Yeah, I guess what I'd add is that it shouldn't be disqualifying, but it shouldn't be the only qualification. As John said, there are lots of people who can do these jobs and can do them well. And the fact that you were in the legislature doesn't mean, again, all other things being equal, that you're going to be better at it. And it does, over time, raise some of these real issues that John's mentioning involving separation of powers. This isn't wholly theoretical. What do judges do? They interpret state statutes. Who writes the state statutes? If it's their friends in the General Assembly, we might be concerned about whether they're going to view this with an open mind. And if you think about a real conflict, like, and this case got settled, but the constitutionality of the legislature's pension reform bill, do we think the court that's reviewing the constitutionality of that should be made up entirely of former legislators who are presumably deferential to their colleagues, notwithstanding their judicial independence? They came up through that system. So mixing it up is, I think, a really important point.
So let me ask you both this. If I'm a member of the public in Rhode Island, it's a tiny little state, and it's hyper-connected, right? Everyone's 1 degree of separation away from everyone else. How is it not possible that judges are going to be connected in some way? Like, I feel like that's what I would think about as a Rhode Islander, right? Like, we constantly talk about how close we are. How do we avoid that in a place like Rhode Island?
So I think it's both one of our great strengths as a state and one of our serious weaknesses, because it is natural in a state that is this small, right? So Montana has the same population roughly as Rhode Island, but it covers about 100 times the land mass.
Exactly. I was just in North Dakota, and there's 300,000 less people, and it's ridiculously larger.
You could fit 110 Rhode Islands in there. So people are going to be
First
related.
of all, I'm sorry. How much time do you spend figuring out how many Rhode Islands there are in the different states?
That was roughly 110. Don't.
Would you be willing to come back and just have an episode on how large things are in terms of Rhode Island?
So
I'll take that as a yes.
everybody, people are going to know each other. People are going to be related to each other. Again, I don't think it should be disqualifying, but just because you're somebody's brother, sister, daughter doesn't make you more qualified. And I do think it's important for anybody applying for these positions to realize they need to think not just about their ambitions. They need to think about what it would mean for public confidence if they get the gig. And so sometimes it would be better for the judiciary long term if someone who's super connected politically or related to somebody who's already on the bench to say, you know what, this is the only job, this is the only lawyer job in Rhode Island I shouldn't do. Now, that's hard, I think, to ask people. It's a really good job. But decisions people make have consequences.
Yeah. I think about our students for a minute. 85% of our incoming class don't have lawyers in the family. And are they being excluded, right? Just something to think about.
I also think about the judges we do have. And I think about the work that we do every day and how sometimes we are asking people to give up power or to put down power or opportunity for the sake of a more fair system or more justice. And it's hard. It's hard to be the person asking people to give up their power. And it's got to also be really hard to be the person in power or have the potential to be in power and to say, hey, but I think that this is the best job that I think it would be best for this position to go to somebody else, especially when, you look up to your dad. Maybe your dad was a judge and this is all you've ever wanted to do. And so there's all this stuff happening behind the scenes, and I have a lot of grace and empathy for everybody sort of in this conversation. But I do want to ask the question, we describe this system as a merit-based system. How do these political connections within the merit-based system impact diversity specifically?
The diversity question is interesting because if you go back and look at the original statute that created the Judicial Nominating Commission, part of the charge, a big part of the charge, is to create a bench that is more racially diverse. And you've looked at the numbers. People have looked at the numbers. We have a far more racially diverse bench than we did in 1994. The state is more racially diverse, but it's been a dramatic change on the bench, and that I think is only possible because we had a governor, Gina Raimondo, I'll give her the credit, who took advantage of her power in this system to use the JNC and use her kind of bully pulpit and appointment power to fulfill that statutory mandate. Sometimes those people were connected, right? As the state, as sort of the legislature has become more diverse, ironically, that those political connections actually help create a more diverse bench. So I would argue that part of the original promise of the JNC has been partially fulfilled, where some of the other parts about sort of severing the tie with the legislature and giving everybody an equal shot, maybe not fulfilled to such a degree.
What about gender?
The gender balance in the court, there are far more women on the court than there were in 93 when the system was enacted. Again, part of that is because the cohort of attorneys who are eligible to be judges has become much more diverse in terms of gender. Nicole, you know that Rhode Island was sort of late to the game in terms of getting women into attorneys' positions. And so that cohort is now getting bigger and bigger. Michael, you know better than anybody, our classes, and we're not exceptional, I don't think, nationally, the number of women in law schools now exceeds the number of men in law schools.
Completely.
So some of this I think was going to happen, but I completely agree with John that it's been accelerated here because of this system and because of the opportunity that people have to say, how come you're not picking A, B, C, D?
Yeah, and I think you made a really good point about like the pool of attorneys is more diverse now, in large part thanks to the law school, and that was one of the reasons the law school was created almost at the same time the system was created, was to build a legal culture unique to Rhode Island of its own, and have the bar be more diverse and reflective of the state's population. But it takes a while, right? You don't apply to be a judge in your second year as an attorney, right? You establish yourself and then you decide to go for one of these openings. And then you get on the bench and you get promoted to a different court or the presiding job or the Supreme Court. And so, it just takes time, and it takes literally generations. And you call this like a baby system. We were the last state to switch to this system in the United States. We went all in, as I've said before, but it just takes time. One of the flaws has been, though, that we didn't fund the system. These 9 people who sit on this Judicial Nominating Commission, they do this in the evenings. They don't get compensated for this. They actually don't even have a staff. They borrow a paralegal from a law firm. So we didn't really as a state invest in a way where they could do active recruitment, So one of the things Raimondo did well is she appointed somebody to chair that commission who went out and actively recruited among the Thurgood Marshall Law Society and groups where she would find a more diverse audience. And she said, her name was Sally. Sally went to the groups and said, like, if you apply, I will give you a shot. I will make sure you have a shot. And that was important because people didn't feel like if they applied, particularly people of color, they had a shot. And at least when Raimondo was governor, they felt they had a shot. And she proved good to her word because she appointed, we had the first time a female majority on the state Supreme Court, the first Black person on our state Supreme Court, or person of color on our state Supreme Court, as well as various other positions.
I just also want to pause and say, you said it like so matter-of-factly, like, oh, we've become more diverse. And that is really, really hard work. And so as we're having this sort of nuanced conversation about this, I just want to make sure that we're all like appreciating the work that has been done. And you can, whether you're Kathy Gregg or you're us or you're the person on the street, it's easy to pick apart the flaws of a system. It is harder to sort of stop and say, there have been people, there have been processes that have been a lot of work, but there's been positive things that have come out of that. And so I just appreciate the nuance that we're having in the conversation that like, it's not all bad, it's not all good, it's complicated.
Yeah, and there's a couple people specifically, right? So I mentioned Gina Raimondo, but like you were involved in the early days helping the JNC write their rules, right? And, I would argue they should have hired a staff, but they relied on volunteers.
Subpar work, Michael.
They're good
you
rules.
You get what you pay for.
And, but there was somebody we both worked with named Alan Flink who passed away a couple of years ago, who was an attorney at a big firm, never wanted to be a judge. And that helped him sort of be a loud voice on behalf of the system served on the JNC.
And didn't appear in court, I don't think, in Alan's practice.
And so he, they're sort of hidden heroes of the story here. And a lot of well-meaning JNC members over the years who worked hard, spent countless hours listening to the testimony. So there are a lot of folks who put in a lot of work to get us the successes we've had. Are there flaws? Yes. Are there efforts to undermine the system as we speak? Absolutely. There are going to be at least one bad bill in the legislature next session to undermine the system. But a lot of hands went into making this work.
So aside from the Kathy Gregg article in Projo, you also wrote a law review article on this topic. And on the idea that the reforms haven't fully lived up to their potential. What changes would need to happen? And this, I guess, is a question for both of you. From your perspective, what changes need to happen for Rhode Islanders to really be able to trust how judges are chosen?
Yeah, I mean, I think there are a few things. One thing I'd like to see is those appointments to that Judicial Nominating Commission be made in a timely fashion. We've seen a lot of people stay on that thing way too long, particularly people who are kind of politically juiced. The former speaker's law partner, who's now a magistrate, was on it for like a decade, and was clearly, I think, doing the legislature's bidding on there.
They're supposed to be 4-year terms.
Yeah, and
how long have people been on?
Yeah, he was on for about a decade,
wow.
more than 2 full terms.
Maybe they don't have enough people who want to sign up. Maybe I could be the next Judicial Nominating Commission member.
Please no.
And maybe you could, and it would be
don't encourage her.
Good. 8 of the 9 members are on expired terms right now. I'd like to see the members of that commission actually barred from speaking to people about the candidates. It's called ex parte communication. I'll pretend to be a lawyer there for a second.
Well done.
But
wait. So for those of us who aren't lawyers, Michael Yelnosky, what is an ex parte communication?
I think in this context, what John's referring to is a commissioner having a private conversation with an applicant for a judgeship.
Yeah, or somebody representing the Speaker of the House or somebody representing the Senate President. These conversations happen, right? Like I had somebody just the other day who applied for one of these positions call me to kind of ask me about the process. And he said, yeah, I'm making phone calls, right? Like I'm trying to whip votes for my application. And we need to figure out a way to kind of reduce that insider communication that I think undermines the system to some degree. And then I would like to see, sort of continued efforts, particularly by the governor, to try to push both the JNC to be diverse, because that has always been lacking, but also just to kind of push back against the legislative leadership when the legislative leadership tries to impose their will on the governor, that sort of this is my pick. We know from some reporting, that governors, we have a very weak governorship as an office in the state, and if they want something, oftentimes they're probably asked, well, if you put my person on the bench, maybe you'll get this thing in your budget through. And we'd like to see governors kind of push back against that. They're institutionally weak to do so, but nonetheless, they need to recognize like they play an incredibly important role in picking the leadership of an entire branch of government. And they shouldn't let other people try to kind of get their hands on that power.
Well, thank you. I think this has been an incredibly insightful conversation. We've hit just the tip of the iceberg, and I think it's a topic we will be coming back to. So Nicole always closes us out with some fun question. Nicole, what is your question of the day?
Well, now that we know a little more about Justice Thomas Fay, my question for all of us is, who would you cast to play Justice Thomas Fay in a Rhode Island-centric scandal movie?
So I have an idea.
Okay, what is it? Lay it on us.
So he was Irish, so I'm thinking Irish. Mm-hmm. And there's an actor by the name of Aidan Gillen who is Irish. He played an Italian guy in The Wire. He was Mayor Carcetti. And I think...
First of all, could we just have you come back and talk about The Wire?
So my vision of Chief Justice Fay, which is completely uninformed, is that, although I've heard people talk about him, that like Carcetti, he was a well-intentioned guy. And I think many people say an honorable guy, as Carcetti was, who got corrupted by the system. And I think this system could corrupt you because, as John said, there was no line between the General Assembly and the Supreme Court. If there was a line, it was a horizontal line. Mm-hmm. And he did what you're supposed to do. They give you the Chief Justice position, you give the Speaker of the House a good gig, and then the two of you start giving out favors. So Carcetti's arc is a little like this in The Wire, and so he's my guy. They bear some faint physical resemblance, but...
Yeah, so I was not in the state in the 1990s. I moved here in the 2000s, so I don't remember these people. All I can go on is what I read in the archives, as we were discussing before, of the newspaper that I can access, don't have the pictures, which stink. So I don't even know what he looks like. But I like this idea that he's Irish, middle-aged Irish actor. So and the last name's escaping me, but what is Colin?
Oh,
Farrell?
Colin Farrell.
Farrell, right?
Wow.
Sort of. Yeah. I mean, let's I'm sure he didn't look like Colin Farrell, but like, let's live the best version of Rhode Island corruption we can and cast an A-list good-looking celebrity.
So Nicole,
This
who would you
is a
choose?
hot take because I refuse to watch Colin Farrell movies.
Oh, wow.
I
did
deeply
not know.
dislike Colin Farrell movies after I watched a really bad Colin Farrell movie and I just said, that's it. Although sometimes he creeps into movies halfway through and you don't want to turn it off at that point. My answer is based on pictures. I also didn't live in the state in the 90s. Mine was, I thought Justice Thomas Fay looked like that guy, Anthony Edwards from ER. I was like, oh man, that's Anthony Edwards who's going to play that guy.
And I Googled him as well and saw William H. Macy.
Oh,
Right.
nice.
Oh, nice.
Wow.
Yeah, I think that'd be a good call.
Yeah, we have a panoply of responses.
So we want to thank you for tuning in for this episode of Law 401. We will be back next Tuesday. In the meantime, if you've enjoyed this episode or you're enjoying our podcast, please subscribe on Apple, on Spotify, on all the platforms. Leave us a review. Help us get engagement so more Rhode Islanders can find us. Nicole?
See you next Tuesday.
Thanks for tuning in to Law 401, Legal Issues Decoded from Roger Williams University School of Law. We'd like to thank our guests on the show today. The Law 401 podcast wouldn't be possible without the generous funding from the Hassenfeld Family Foundation. We'd also like to thank executive producer from RWU Law, Helga Melgar, the RWU Marketing and Communications team, podcast social media manager, Ali Michelle Conti, and our production partner, Focus Forward Media. The opinions expressed on this podcast are those of the hosts and guests and do not necessarily reflect the views of Roger Williams University or our partners. For more Law 401 episodes and updates, follow us wherever you listen to your podcasts on YouTube or visit law.rwu.edu.